few points about some concerns I have with the draft that would have a negative impact on our ability to best serve our community today. So, for instance, there's a suggestion that if an officer, and I'm paraphrasing directly from the draft, if an officer fails to record the entire contact, court, grand jury, and so forth, shall draw reasonable negative evidentiary inferences against the officer. I understand that it's important for us to record and be able to present a full image. However, that particular language is so limiting, it doesn't take into account the fact that it is, frankly, still somewhat of an emerging technology that's reliant on an old technology called batteries. If you've ever used a flashlight, over time, batteries degrade and they would shut off. And it's not the officer's intent. It's certainly not the officer's intent, but there may be instances where the camera just ceases to function, and it's not something that the officer has done. If there was a deliberate action on the part of the officer to shut off so that they were no longer being filmed, then we could have a conversation about a negative evidentiary inference. But for an incidental recording, cessation of recording, it's too limiting.
Just also another point on that is we use Concord Hospital. So say we make a DWIRS, we get to take the blood. Concord Hospital will not allow the camera to be used. The officer has to shut the camera on. So hospital policy dictates we can't run on camera, but if, as drafted like this, the trier of fact would have to interpret that negatively. And I think that's fair because we have to follow Concord Hospital's policy. So in that area, like you said, as broadly written as it says, I think is a big issue for us.
Further along, there's a section that calls for all access to body-worn camera data shall be authorized by the Director of the State Police. How, as the Chief of Police, how am I supposed to regulate the use of the cameras? How am I supposed to review the data? How am I, those types of things, without the permission of the Colonel of State Police? That doesn't seem to make any kind of sense from a local standpoint at all. I understand the emotional sentiment behind the desire to have body camera images available to victims and families of victims following a violent incident. However, requiring it, as in this instance, shall within 5 business days receive a copy of the recording, that's unreasonable from the standpoint of ongoing criminal investigations. That's outside of the law enforcement's control. Largely, it's been my experience that once an incident such as that occurs, the New Hampshire Attorney General's office is investigating these incidents, and I would not have control over those images. I would not be able to release those images. It would be, again, an unreasonable expectation. Another concern I have is the suggestion that the images that were taken be destroyed or overwritten within 14 days, with some exceptions listed. Very frankly, the Weare Police Department is a small police department, and though our officers that are in the field wear the body cameras every day, we still record a considerable amount of video. For us to try and comply with the 14-day requirement, and also have the possibility of the exceptions, I would just about have to hire a full-time person to be reviewing, editing, storing some images, destroying other images. It would be a financial impact on the community that I don't think is reasonable. There's room for work there.